Attorney Schaefer. Today on What You Really Want to Know, we take a look at who is eligible to get a green card through the Violence Against Women's Act, also known as VAWA, and what are the requirements to apply. If you do not have a green card, and you or your child were battered or abused by certain U.S. citizen or lawful permanent resident relatives, you may be eligible to file a Violence Against Women's Act or VAWA petition. Despite the name, both men and women can apply for VAWA. Just like a marriage petition, a VAWA petition can be filed concurrently with the application to adjust status, which is the application to get you a green card. Unlike a marriage petition, you may still be eligible to file for VAWA and a green card, even if you entered the country unlawfully without the need for a waiver. So what are the requirements for VAWA? There are several. The first requirement is that you have a qualifying relationship with an abusive U.S. citizen or lawful permanent resident. There are three categories of qualifying relationships: spouse, child, parent. To file as a child, you have to be under age 21. However, you can file up to age 25 if the abuse caused the delay in filing. You have to be unmarried, and you must have been abused by a U.S. citizen or lawful permanent resident parent. To file as a parent, you must have a U.S. citizen son or daughter. You must have been subject to abuse by your U.S. citizen son or daughter, and your U.S. citizen son or daughter must be age 21 or over when you file the petition. And finally, to file as a spouse of an abusive U.S. citizen or permanent resident, you have to either be currently married to the abusive spouse or previously married to the abusive spouse. If you're no longer married to your abuser and your marriage was terminated by death or divorce, you have 2 years from the date of the death or divorce to file the VAWA petition. In addition, if it was terminated due to divorce, the divorce had to have been based on abuse. The second requirement for VAWA is that you must have lived with your abusive spouse, parent, or child at some point for some period of time. The third requirement is that you're a person of good moral character. The fourth requirement is the extreme cruelty or battery element. In general, you have to have been the one who suffered the extreme cruelty or battery by your U.S. citizen or permanent resident relative, with one exception. If you're filing as an abused spouse, you can file based on the abuse your child suffered at the hands of your spouse, even if you personally were not the subject of the abuse. And the final factor, number 5, to file for VAWA, only applies if you're filing in the spouse or child category. If you're filing as an abused spouse or child, then you also have to show that either yourself or your parent entered into the marriage in good faith and not solely to obtain an immigration benefit. VAWA petitions are challenging due to a lack of available evidence. A lot of VAWA petitioners, unfortunately, are forced to run away from their marital home and are either unaware of the evidentiary requirements or unable to preserve many of the key pieces of evidence needed to establish its eligibility. This is why it's essential to have an experienced VAWA lawyer assist you in the process, as we can ensure you that you give yourself the best opportunity, the best chance possible to present your case and help you locate and obtain all of the necessary evidence. VAWA petitions are sensitive in nature. The facts that lead to someone needing to file one of these petitions are often upsetting, overwhelming, and emotional. Many victims of abusive domestic relationships are unaware that they're even victims. In fact, many cases in our office for VAWA, they start when a client first comes into us because they're in the country unlawfully and either their marriage is on the rocks and there's been no marriage petition filed yet, or a marriage petition was filed before their marriage started to go bad, and now they're worried because if they leave their spouse, that will mean they need to leave the U.S., and most likely their chances of ever obtaining legal status in the U.S. is looking like slim to none at that point. But after a brief discussion with many of these clients, we determined the client's actually being abused. And we're able to determine this relatively quickly because abusive domestic relationships generally follow a similar pattern and display similar red flags. In these cases, our first concern is our client's safety, and we ensure this before we dive into any immigration matters. We first will discuss with the client what steps he or she can take to protect himself or herself. Depending on the circumstances, we've advised clients everything from immediately, that second, calling the police, to going to family court to file for an order of protection, leaving the marital residence for good, as well as many other precautionary measures. Once we know our client is safe, we will determine his or her eligibility to file a VAWA petition. The important things to know is that you're not alone, and your abuser will not be notified if you file a VAWA petition. If you think that you may be eligible for VAWA, or you're afraid for you or for another family member for their safety, contact us today for help. That's all for this episode of What You Really Want to Know. Thanks for watching.